And welcome back to Passing the Baton, the estate planning podcast from Tracktown Law. My name is Jared Hight, and I am your host for today's episode. Tracktown Law is a virtual law firm in Eugene, Oregon, serving clients across Oregon and Idaho with flat fee estate planning and small business services delivered online. Today we are tackling Medicaid planning. It is where medical need, money, and law all tug on each other at once. If you have aging parents, a spouse with declining health, or you just want to protect what you have built, this is the conversation that keeps families from getting blindsided. By the end, you will understand how Oregon's eligibility actually works, why Oregon's income cap means you may need a Miller Trust, how a Medicaid Asset Protection Trust fits in, and what order to do things in so you are not guessing when care is suddenly on the table. Quick disclaimer before we dig in. I am licensed in Oregon and Idaho. This show is educational. Listening does not create an attorney-client relationship, and this is not legal advice. If you want advice for your situation, book a free consultation at tracktownlaw.com. Let's start with the two gates you have to pass through. First is the medical gate. Oregon requires a nursing facility level of care. That means help with activities of daily living like bathing, dressing, eating, toileting, or mobility, or a cognitive impairment that makes independent living unsafe. You can have no money and still be denied if you do not meet the care standard. You can also be very sick and still be denied if your finances are over the limits. You must meet both gates. Now the financial gate has two halves, assets and income. Assets first. For a single applicant, the countable asset limit in Oregon is just $2,000. Certain things are not counted, like your primary residence when a spouse still lives there, one vehicle, personal effects, and specific burial funds. If you are married and only one spouse needs care, the law protects the community spouse from being wiped out. In 2025, Oregon allows the community spouse to keep up to $157,920 of countable resources, and there is a minimum floor just over $31,000 if the couple's savings are modest. Those figures adjust periodically, but that is the range this year. The spouse who needs care still has the $2,000 limit. Now, income. Oregon is an income cap state. The 2025 cap for long-term care, Medicaid, is $2,901 per month in gross income for the applicant. If your monthly income is at or below that number, you have cleared the income half of the financial gate. If your income is even $1 over, you will not qualify unless you use a Miller Trust, which Oregon calls an income cap trust. Here's the key correction that trips people up. In Oregon, all of the Medicaid applicants' income must be deposited into the income cap trust each month, not just the amount over the cap, all of it. The trust is irrevocable. It has a special payback clause to the state at death, and it runs through a dedicated bank account with a trustee handling deposits and distributions. From that account, funds are paid out in a specific order each month. First, small deductions the rules allow, like a personal needs allowance, currently about $79.07 per month for someone in a nursing facility. Next, health insurance premiums like Medicare. If you have a spouse at home with limited income, the rules may allow a spousal allowance so the healthy spouse can meet a basic budget called the minimum monthly maintenance needs allowance. After those items, the rest goes toward the patient liability, which is your share of the nursing home bill. The effect is that your income no longer disqualifies you, because you have given up direct access to it, and the distributions follow the Medicaid order of operations. That is exactly what the state requires. So the Miller Trust solves an income problem. What about assets? How can you ensure that your countable assets are below the $2,000 allowed? That is where a Medicaid Asset Protection Trust, or MAPT, can be a powerful tool if you plan ahead. A MAPT is an irrevocable trust you set up and fund before care is needed. By transferring assets, such as your home or investment accounts, into the trust, you remove them from your personal countable resources for Medicaid while still keeping control over who inherits them after you die. The trade-off is real. You cannot use the principal for yourself once it is in the trust. You may reserve certain rights like changing successor beneficiaries, and some people reserve the right to receive income the trust generates, but principal access is off the table. If you later apply for Medicaid and you are receiving trust income, that income will be treated like any other income. In Oregon, that means it must flow into the income cap trust along with your other income when you are using a Miller Trust. Timing is the heart of MAPT planning because of the 5-year lookback. Oregon reviews your financial history for 60 months before the application. Gifts and transfers below fair market value during that period can create a penalty that delays eligibility. That includes transfers into a MAPT during the lookback. That is why the MAPT is an advanced planning tool. It is best done while you are healthy enough to wait out the clock. If you are already inside the 5 years and need care now, a new MAPT will not fix the immediate problem, although it can still protect assets for the future once the penalty period runs its course. What about couples where only one spouse needs care? The toolset is different and often more flexible. Oregon's spousal impoverishment rules allow the community spouse to keep assets up to that protected ceiling I mentioned earlier. Income earned by the healthy spouse is not counted against the applicant, and there is a monthly maintenance needs allowance range for the spouse at home. Transfers between spouses are not penalized, and crisis, strategies like Medicaid-compliant annuities, can sometimes convert excess countable assets into an income stream for the community spouse without triggering a transfer penalty. That is not a blanket recommendation. It is a reminder that the rules are designed to avoid impoverishing the spouse who stays home, and there are lawful ways to fit inside those rules even when care is urgent. Let's talk about the usual order of operations when advanced planning is in place. Step 1 is medical. Confirm that the applicant meets the nursing facility level of care standard. Step 2 is inventory. Gather a full picture of assets, debts, income sources, beneficiary designations, and how each account is titled. Step 3 is analysis. Categorize exempt assets from non-exempt and decide what must be spent down, what can be repositioned, and what is already protected. Legal fees for Medicaid planning are an acceptable spend down. Step 4 is implementation. If you are planning far enough in advance, this is when a Medicaid Asset Protection Trust is drafted and funded. That starts the 5-year look-back clock running. Once the 5 years have passed, those trust assets are no longer counted for eligibility. When the time for care arrives, the focus turns to income. If the applicant's income is over the cap, an income cap trust is prepared and funded. All of the applicant's income is routed into that account each month and then distributed in the order required under Oregon's rules. At the same time, any non-exempt assets outside the trust are reduced to the allowable limits through lawful spend down or by shifting them into exempt categories. Step 5 is application. Once the medical need is documented, the assets are within the limits, and the income cap trust is functioning, the Medicaid application is filed with documentation supporting every entry. A couple of practical notes. So expectations match reality. The personal needs allowance in a nursing facility is small in Oregon, just under $80 a month right now. Families are often surprised by that. It is intentional. Medicaid is designed to pay for necessary care, room, and board, while the resident keeps a token amount for toiletries and incidentals. If you're married, the spousal allowance calculation is where the program tries to keep the lights on at home. It uses a statewide floor and ceiling that change over time. If you are single, there is no spousal allowance, and most of your income will go to the facility after the small personal needs amount and any health insurance premiums are covered. Also, do not panic if a number you read online is a little different next year. The income cap, the personal needs allowance, and the spousal standards are adjusted periodically. Check the current figures when you are actually applying. Where do MAPTs and Miller trusts meet in the real world? Here's the pattern. Families who plan early use a MAPT to move the home and investments out of countable resources and then wait out the 5-year look-back. When care is needed, they clear the medical gate, then fix income with a Miller trust if the cap is an issue, and apply. Families who come in during a crisis focus on the Miller trust immediately if income is over the cap, then use lawful spend down and spousal protections to get to eligibility as quickly as possible. Either way, the framework is the same. Meet the care standard, get under the resource limit. Route all income through the Miller Trust when you need it. Then file a clean, complete, and documented application. A quick word for Idaho listeners. Idaho is also an income cap state that uses qualified income trusts, the Idaho term for a Miller Trust, and Idaho has the same 5-year look-back framework. The exact dollar amounts and a few mechanics differ, so if you are in Idaho, we can walk through your state's specifics in a consult. The point of all of this is not to game the system. It is to accept the math. Long-term care can burn $10,000 a month for years. Medicaid is the safety net for care once you meet the rules. Planning is how you protect a spouse, preserve a family home, and give your kids a chance to inherit something rather than a stack of old invoices. If this raised questions for your family, there is a companion blog post on tracktownlaw.com that covers the highlights you just heard. You can also schedule a free consultation on the site. We handle the trust drafting, the income cap trust setup, the spend down plan, and the application strategy, and we keep it as straightforward as possible. Thanks for listening.